Good morning, Mr. Smith.
Morning.
Um,
Morning to the court.
did we reach out to Mr.
I did, I have not heard back from Mr.
So these are only on the new cases, is that correct? The 26 CR 2435?
Yes.
Okay.
That is his first appearance, it's just to set, today is just to set prelims.
Give me a moment just to look at your case.
Yes, ma'am. Take your time.
So we will schedule you for a preliminary hearing.
It was supposed to be today.
Sorry?
I was told in court just the other day that prelim would be today.
No, it was set for a preliminary. It was to set it for a preliminary hearing. The preliminary hearing is not today.
Today's the 10th?
Yes.
Okay. Yeah, the judge had said that the prelim would be set for today. That's why I'm here.
So, Your Honor, the note from BDA Finkelstein does say to set preliminary hearing. So
Yes.
this wouldn't be the setting.
The information from the minute order from Judge Brady was that this case was to be sent to Division 12 for an Arguello advisement. So that's your right to represent yourself. We'll do that in a moment. And to request to set the preliminary hearing within 35 days. It was not set for a preliminary hearing today. We do not set our preliminary hearings at 8:30. We set them at 1:30 in the afternoon. So this was to advise you as to your right to represent yourself, which I will do in a moment, and to schedule to set the preliminary hearing at the next court date. So we're going to be setting for preliminary hearing today.
Okay.
Um,
And that's clearly my misunderstanding.
But, it's confusing, so not a problem. So there's a couple of things I want to address with you. First is, I know you have been advised previously of your right to represent yourself, but in each case, I need to advise you as to that right, okay?
Yes, ma'am.
You understand that you have the right to be represented throughout these criminal proceedings. And if you could not afford an attorney and you qualify, one would be appointed to represent you, correct? You understand that?
I hear you.
Okay. The high charge is a class 4 felony. Because you were on bond,
And actually, because it's a per se COP per the statute, the sentencing range would be 5 to 16 years. That is not mandatory for this particular count. Because it is a COB per se, the bond status is not a relevant factor to the increase of any potential sentence for that. So
all right, thank you. So the high charge is the count 2 that carries with it a presumptive range of 5 to 16 years in the Department of Corrections. If sentenced to the Department of Corrections, it would carry with it a mandatory period of parole of 3 years. Do you have any legal training, Mr. Smith?
Well, before we begin, may I put something on the record? Okay, so I want the record to reflect that I'm appearing in a limited capacity for the sole purpose of this procedure. I hereby reserve all rights under the United States Constitution and the Colorado Constitution. I explicitly do not waive any rights of any kind, whether known or unknown. Furthermore, I have not consented to the jurisdiction of this court. I'm appearing under compulsion of process to ensure that my constitutional protection is against warrantless seizures and lack of due process or appeal.
Okay. Do you have any legal training? Let me ask you this. Do you have any formal legal training?
I think I may need to object. I don't understand any of this. Okay.
Okay.
However, I am I'm still trying to wrap my head around this whole thing. And so I want to just make clear I'm under duress and I am trying to put all this together.
All right.
Okay,
Well, so one of the things that I need to do, that I'm required to do by Colorado case law, is advise you as to your right to represent yourself. You do have that right to represent yourself.
okay,
And, but I do want to have a better understanding as to your understanding of criminal procedures. So for example, somebody may be very familiar with the Constitution and the rights that you have under the Constitution.
okay,
They may be less familiar with trial procedures and things that you need to do to represent yourself in a manner that gives you the best opportunity for your defense, understanding that you're presumed innocent until 12 people would make a determination that the prosecution has met their burden. So that's why I'm asking these questions. I'm not trying to necessarily get into your personal life or what.
He walked into court thinking today was his big day. Wrong. Watch what happens when a man challenges a judge's jurisdiction in her courtroom. Will it actually work?
Your actual beliefs are. I'm just trying to find out where your education is in terms of, that's why I said, do you have any formal legal training?
right.
Like,
And I guess where I'm at as far as this whole procedure is concerned, I understand your role in part, and me gaining better insight about my role in part. It's my understanding that there's some things that have to be proven on the record prior to being to proceed to any trial or anything. My understanding is that the DDA and the people have to prove jurisdiction before moving forward towards any trial. This is before any plea deals can be made or rendered as well.
so I did see the motions that you filed,
Okay,
and I can just kind of address those right now. We'll get back to the advisement.
sure.
So, quo warranto, that is basically establishing who has authority to bring these charges against you. Under Colorado Revised Statute 16-5-205 and Criminal Rule of Procedure 7, the district attorney has been authorized by the Constitution and ultimately the legislature to file these charges against you. Subject matter jurisdiction basically is Colorado Revised Statute 18-1-201. Basically, any crime that is alleged to have been committed in the state of Colorado grants the state of Colorado subject matter jurisdiction. Your presence in court confers personal jurisdiction. So the court is finding that it has jurisdiction over this case.
You said my presence in court?
Yes,
Okay, which is only under duress.
I understand.
Right. So if we're basing it on, I'm assuming that these are prongs that constitute consent of jurisdiction. That last prong does I guess translate into consent jurisdiction by my appearance here.
Yes.
Okay. Well, I'm not.
But if you
giving
don't appear in court, then the court issues a warrant for you.
Court issues a warrant. So again, because even the name that you guys are charging in itself is hearsay.
Okay.
And it's speculation.
So we're going to have
So
to
I want
agree to disagree on this right now because the case law is pretty specific
Yes, ma'am.
that the arguments that you're making have not been accepted by the appellate courts. And I understand that you will,
What argument? I'm sorry.
that basically by that, possibly the court doesn't have jurisdiction over you or that.
I'm asking the court to prove that it has jurisdiction over me as a.
Well, a charge has been filed in the state of Colorado.
Okay.
At the early stages, we only have to determine that whether or not there's probable cause. All right. At the time of a trial, if you choose to go to trial, the prosecution would have to establish that this crime occurred in the state of Colorado. That's one of the elements as to each charge, that the defendant in the state of Colorado did X, Y, and Z. Then the jury would have to decide, yes, that the prosecution has met their burden of proof, that this crime that is alleged to have occurred actually did occur in the state of Colorado. So that's when it gets proven. At this stage, we're just operating off of probable cause. We're not operating off of proof beyond a reasonable doubt. A jury would ultimately determine whether or not
He boldly told the judge, "I don't consent to your jurisdiction." Her response? Ice cold. This argument has never won in appellate court. Not once. Ever.
this case, this crime that is alleged to have occurred in the state of Colorado.
Wouldn't there be a hearing prior to this trial to determine if this case
No,
would
that's the,
move
well,
forward to a trial?
so,
If so, why
so
didn't I have?
because if you're entitled to a preliminary hearing, again, at a preliminary hearing, the only thing that the court is determining is whether or not there's probable cause, not proof beyond a reasonable doubt. So when we go to a preliminary hearing,
So that's prima facie, is that correct?
I'm sorry,
That would be deemed prima facie?
deemed prima facie?
Yeah,
No, it has, it's not prima facie. They have to, it's probable cause. All right, that a person of ordinary prudence and caution, reasonable belief that this crime occurred in the state of Colorado. They will have a witness, or they should have a witness. They may not, but if they have that witness will be able to testify to certain things. If they don't testify that the crime occurred in Colorado, then the court would not be able to find probable cause. If I can't find probable cause, then the charge is dismissed. But we don't
all
have
the way
to,
to the, I guess, to the trial date to be able to distinguish the facts
yes, for proof, for conviction.
for conviction.
Yeah.
Okay. Do you contend then the jurisdiction has been proven already? That
What I am saying is that a judicial officer has already determined that there is probable cause. I'm not saying it's been proven beyond a reasonable doubt. You keep using the phrase proven. All I'm saying is that someone has made a determination that there is probable cause that a crime has occurred in Colorado.
okay.
For it to be proven, we have to go to trial, and a jury has to make that decision.
Okay. I think we're speaking about two different things. My consent to the jurisdiction of this court, and you're speaking towards the case, whether or not the case is can be heard in the state of Colorado. It sounds like we're talking about two different things. Or is,
Charges have been filed against you.
yes, ma'am.
Some officer, judicial officer, other than myself, has made a determination that there's probable cause to go forward with those charges. At the preliminary hearing, I will again make a determination as to whether or not there's probable cause to go forward with the felony charges, not with the misdemeanors. If I determine that there's probable cause, then the matter is bound over and gets set for trial. If I don't determine that there's probable cause, then the charges get dismissed.
Okay.
Okay? You had also raised something about habeas corpus writ. That's not really applicable here because you are not currently being detained.
It was during my detainment that it was written and submitted.
Okay. And then you had also addressed something about requiring a verified complaint. The prosecution under Rule 3 doesn't have to file a verified complaint. It just has to be signed by the prosecutor. The only complaints that have to be verified are those where they are also requesting a warrant at the same time, because probable cause was found by a judicial officer in which a law enforcement officer swore to the facts as he or she was aware of them. Based upon that sworn affidavit, then someone determined that there was probable cause. So getting back to the advisement that I have to give you, You never really answered the question for me as to whether or not you have any formal legal training.
Second.
How far have you gone in school?
Give me
Okay.
1 second, okay? Thank you.
Oh, sure.
So in regards to the those two writs, what was your decision on that?
I'm denying them. If you would like, and I will do it anyway. I'll just issue a kind of a formal order denying it. So you have further information as to what I'm relying upon to deny it.
Yeah, I'm going to request a written copy of the advisements and the formal charges.
You're requesting a what?
Properly served with an actual notice required by due process to understand the specific scope of the state's allegations.
Sir, if you could let me finish doing what I'm doing.
Yes, ma'am. Yes, ma'am.
Yeah, and then we can finish this so I don't lose my spot, and then you can make any further.
Understood.
Yeah.
Understood.
How far have you gone in school?
I have so many questions. Can you proceed without me answering?
Not really. And the reason being is I need to know if you representing yourself is presenting a great detriment to your defense. And this isn't under oath or anything. I'm just trying to make sure that you are fully understanding the consequences of you choosing to represent yourself as opposed to having an attorney represent you. Some of the arguments that you have raised either in your motions or in court, and I don't say argument as meaning you're arguing with me, just your positions. I'll say some of your positions have been raised by other individuals before, and generally similar arguments that have been raised have not been adopted by the appellate courts here. And so I appreciate your positions as to whether or not you think the court has jurisdiction to go forward with these hearings. But I will tell you, I've researched these issues before, and generally they have not been, your positions have not been adopted by the courts. And when I say the courts, I mean the appellate courts. And so my concern is for you that you may be relying on things on the internet or other things that people have told you that have not been accepted by the courts, and that may work to your detriment.
What can you tell me what things those are?
Well, if you're talking about, I haven't consented to jurisdiction, you have been charged with a crime in the state of Colorado. We're going to go forward with that until either if the district attorney chooses to dismiss a case, or we take the matter to trial, or you accept a plea. So for you continuing to say, well, I'm raising jurisdiction, I don't believe that I've consented to jurisdiction, and I'm not sure the state has jurisdiction. I'm not sure that the district attorney has authority to file these charges against me. Those are things that have generally been raised by individuals other than yourself that have not been adopted by the Court of Appeals. And so what I'm really just trying to make sure that you understand that representing yourself in this case can put you at risk of liberty, if I'm being perfectly honest. By you not adequately representing yourself, it could be that a jury may find that you are guilty. And then if you are guilty, as we talked about before, there's a possibility of a lengthy prison sentence. And so I want to make sure that you fully understand, by not relying on an attorney to represent you and simply relying on something that you may have found on the internet, I believe you're putting yourself at risk.
Thank you. So
I need to go forward with this. If you don't want to answer the questions, that's fine. I'm just going to go ahead and advise you as to what they are. You have not indicated that you have any legal training. You have not indicated to me that how far you have gone in school. Are you under the influence of anything, any drug, medication, alcohol, anything that's affecting your understanding as to what's going forward today?
No, ma'am.
Okay. Do you want to consult? I have currently 4 public defenders in my courtroom. Do you want to consult with any of them before you make a decision to waive counsel and represent yourself?
Okay. I do want to go put on the record. I'm not an attorney. I'm only exercising my constitutional rights.
And so this is my thing. I want to make sure that your rights are exercised appropriately. And let's say we were in a trial today. If you were having to constantly look at your phone to make sure that you're asking the right questions, or objecting to evidence that the prosecution may be trying to introduce, I don't think that's going to be to your benefit at a trial in front of a bunch of jurors, right? And I'm not even going to allow you to, well, that's not true. So you say you're exercising your constitutional rights. These 4 people here are very good attorneys.
Okay.
And they understand the Constitution, and they understand the rules of procedure, and they understand the statutes, and they understand what you could possibly be facing by if you are
I'm aware of the
convicted.
penalties. It's just a trust factor.
Okay.
This court is foreign to me. I have no relationship. I have no knowing or understanding of anyone here. And so I'm doing my due diligence to gain the best knowledge in order to combat this scenario. And so because of my lack of faith and trust in the judicial system based on my experience, which has been my own personal experience, what's been in the news and so on and so forth, I'm not altogether trusting of the public defender's office with my scenario. And so
And
I
I'm not meaning to, you know, you and I are in different situations, right?
we
And
are
so,
totally different positions.
and so your lack of faith and trust in the judicial system, that may, I'm going to say that based upon you're telling me your experience, you don't have trust in it. That's fine.
I'm just concerned about the lack of due process and the
Well,
inaccuracies in the state's record against me.
okay. We're going to go forward. My assumption is then you do not want to consult with any of these public defenders before you make your decision to waive counsel. Is that correct?
I'm sorry, say that again.
You do not want to consult with any of the 4 attorneys who are from the public defender's office before you make your decision to waive counsel.
Correct. Let's move
Okay.
forward.
Okay. This might be kind of a redundant question, but you do understand that criminal law, complicated area, having an attorney trained in this field could be of great help in helping you prepare and represent yourself in the defense of this case. So, you know,
I had advisory counsel who is not present.
well, he hasn't, because he wasn't aware, he wasn't advisory counsel in these cases today, and because this got set so quickly from Division 20. But I will tell you, if we go to trial, he cannot ask questions for you. He cannot pick the jury for you. Those are all things, he can make suggestions, he can give you advice, right?
Right.
But-
That's what,
Okay.
That's what I chose to have was you know,
Okay.
be able to ask questions, someone I can ask questions to.
You understand that as we go to trial, you have the right to remain silent.
The judge looked him dead in the eyes and said, "You are putting your liberty at risk." He nodded, and still said no to a lawyer. Facing 16 years. Alone. Why?
But anything you say can be used against you.
I did hear what you said.
Okay. We will go ahead and appoint Mr. Allen in these cases. As you've said, you've previously requested advisory counsel. I'm going to just remind you again that by representing yourself, you take a great risk of not properly presenting your defense to a jury. You have the right to confront any witness who testifies against you and cross-examine them. You have the right to compel the testimony of any witness that you would like to have testify on your behalf. At this point in time, I'm giving you the right to represent yourself. I will go ahead and appoint Mr. Allen as advisory counsel. We have set the matter for a preliminary hearing. At that point in time, the court, after hearing testimony, will determine whether or not there is probable cause to bind the charges over and set this matter for trial. All right. Thank you, Mr. Smith.
Your Honor, I just had a few things really quick to address. First, regarding the defendant's request for a copy of any advisements and formal charges. He did get a copy of the complaint information on the last court date, to my knowledge. If the court is amenable to providing him with any sort of written copy of the Arguello advisements, we wouldn't have an objection to it. I would note that previously Mr. Smith also has been advised regarding the Arguello advisements in the other case that he currently has open. And the people would just ask that the court incorporate by reference in its finding regarding representing himself today the previous advisements that were provided to Mr. Smith.
I haven't looked at those. I haven't previously advised him.
When he began representing himself in the other case, Your Honor, I believe the court did give him an Arguello advisement.
I did not give him an Arguello advisement. I think that happened in DST. But I will go ahead and print out the Arguello advisement. I just printed it to the.
Actually, Your Honor, you are correct. I believe it was on March 9th, 2026. I think Magistrate Percio did provide the Arguello advisement.
Right. So I'm not going to adopt what she did, but I will note for the record that I advised him today and provide him with a copy. It's a generalized copy of the advisement. It doesn't specifically talk about the possible penalties that could be imposed in this case.
And Your Honor, if the court could also, as part of printing that off, just save a copy of what's being provided for Mr. Smith and then upload it to the Register of Actions by means of the clerk.
Sure. But again, that is not the specific advisement that I gave. It is only the generalized advisement because it does not include the possible penalties that he was advised of today. That will be for purposes of the record, which is being maintained by the FTR at this point in time. No,
You said that was an Archwell advisement?
excuse me?
Archwell advisement?
So the Arguello advisement is what it's ARGUELLO. That is the advisement regarding the right to represent yourself.
Got it. I got it right here. Thank you. All right.
All right. Well,
Your Honor, regarding the preliminary hearing, since he's out of custody, I believe that the only charge that is eligible for a preliminary hearing is count 2, and that's by virtue of the fact that it is deemed to be a crime of violence. So count 2 would be the prelim eligible count, and the people will be prepared to proceed on that on the next court date. If for some reason, and I'm just saying this for Mr. Smith's benefit, if for some reason there are any witness availability issues that people do need to raise, that's something that we would make the court and Mr. Smith aware of. I do know that we have 35 days following the filing of charges to provide him a preliminary hearing, unless there's good cause shown for continuing beyond that time frame. I would also encourage Mr. Smith to reach out to the DA's office, as he did previously in the other case, in order to obtain discovery. We're happy to provide that. Mr. Smith, I know you have my email and contact information. If you need to reach me and you have any questions about the discovery process, please feel free to give me an email. I endeavor to be responsive.
I sure will. I sure will. In lieu of this, what transpired, we had corresponded right before that happened. So I'm clearly out and I'll follow back up with you.
Very good. And I appreciate our communication, sir.
I do too as well.
all right. Thank you, sir.
You too. Take care, Mr. Smith.
No lawyer. Motions denied. 16 years on the table. and he walked out, smiling. The real battle hasn't even started yet. What happens next will shock you.